The most powerful man in American law thought he was about to humiliate an actor. Instead, in just 30 seconds, Tommy Lee Jones silenced the entire Supreme Court with a single document no one saw coming. What he revealed didn't just stun Chief Justice Roberts, it rewrote environmental protection for 12 million Americans. The moment that legal experts still can't stop talking about begins now. Chief Justice John Roberts gazed down from the Supreme Court bench, his expression severe as he addressed the silver-haired man standing before America's highest tribunal. Tommy Lee Jones, the Oscar-winning actor renowned for portraying uncompromising lawmen. Despite the electric tension filling the chamber, Jones stood resolute at the podium. "Mr. Jones," Roberts began, his voice carrying an unmistakable edge that instantly hushed the packed courtroom. "You've submitted an amicus brief on environmental law that presumes expertise equivalent to seasoned environmental attorneys. Some might consider that rather audacious for someone who earns his living reciting words written by others." A wave of whispers swept through the gallery. The 8 remaining justices shifted uncomfortably, surprised by the Chief Justice's uncharacteristically pointed opening remark. Jones remained perfectly still, his weathered face inscrutable beneath the harsh courtroom lights. What transpired in the next moments would astonish everyone present. Jones reached into his briefcase and extracted a document that no one in the courtroom anticipated. A document that would instantly transform the power dynamic between the esteemed Chief Justice and the Hollywood actor. Within half a minute, Chief Justice Roberts would be visibly shaken, and the trajectory of one of the most consequential environmental cases in decades would dramatically pivot. Before delving into this extraordinary confrontation that legal scholars continue to analyze, today, comment where you're watching from, and remember to like and subscribe for updates on the most fascinating legal clashes in American history. For years, Chief Justice John Roberts had served as the steady, methodical leader of the Supreme Court, appointed by President George W. Bush in 2005. Celebrated for his brilliant legal intellect and careful judicial philosophy, Roberts had navigated the court through numerous contentious cases. His questioning during oral arguments was typically incisive yet respectful, which made his confrontational tone with Tommy Lee Jones all the more remarkable. Legal observers had noted Roberts' increasing frustration with what he perceived as celebrity intrusion into complex legal matters. In a recent address at Georgetown Law, without specifying names, he had warned against the dilution of legal discourse by non-expert participation. When Jones filed his amicus brief in Sierra Club versus American Petroleum Institute, a landmark case addressing groundwater contamination, Roberts had reportedly told his clerks, "Another actor who believes he comprehends the law." Tommy Lee Jones, however, was not merely a Hollywood fixture. Before his breakthrough performances in The Fugitive and Men in Black, Jones had graduated from Harvard University, where he roomed with future Vice President Al Gore and authored his thesis on Catholicism in Flannery O'Connor's works. What most Americans didn't realize was that Jones had maintained a lifelong passion for environmental science, quietly funding research and conservation initiatives in his native Texas. The case before the court concerned the interpretation of the Clean Water Act as it applied to groundwater contamination, specifically whether corporations could be held responsible for pollutants that traveled through groundwater before reaching protected waterways. The petroleum industry advocated for a narrow interpretation that would shield them from billions in liability. Environmental organizations pushed for broader protection for America's water systems. The stakes couldn't have been higher. The court's ruling would impact drinking water for millions of Americans, establish precedent for future environmental litigation, and potentially cost the petroleum industry billions in cleanup and compliance expenses. Industry analysts were describing it as the most significant environmental case of the decade. Justice Elena Kagan had recently commented during a panel discussion, "This case transcends technical legal interpretation. It addresses the fundamental question of who bears responsibility for environmental degradation, corporations or the public." When Tommy Lee Jones submitted his amicus brief supporting the environmental position, legal experts initially dismissed it. The New York Times quoted, "An anonymous Supreme Court clerk. The justices will give it cursory attention at best. Celebrity briefs usually go straight to the bottom of the pile. No one could have predicted that Jones's brief would become the focal point of oral arguments, or that it would precipitate one of the most unexpected exchanges in Supreme Court history." Oral arguments in Sierra Club versus American Petroleum Institute commenced. The court followed its standard protocol. Attorneys for both sides presented their arguments, with the justices interjecting pointed questions. But 30 minutes into the session, Chief Justice Roberts took an unusual turn. "Before we continue," Roberts announced, "I'd like to address an amicus brief that has garnered considerable public attention." He looked directly at Tommy Lee Jones, seated in the front row of the gallery. "Mr. Jones has submitted perspectives on groundwater hydrology that contradict established scientific consensus. Perhaps Mr. Jones would like to clarify his position." For the court, the request was highly irregular. Amicus brief authors aren't typically invited to speak during oral arguments. A visible ripple of surprise moved through the courtroom as Jones rose and approached the designated podium. "Thank you, Mr. Chief Justice," Jones began, his deep Texas drawl resonating throughout the chamber. "I appreciate the court's attention to my submission." Justice Clarence Thomas, who rarely speaks during oral arguments, leaned forward. "Mr. Jones, I'm curious. What qualifies an actor to instruct this court on complex matters of environmental science and administrative law?" Several spectators suppressed smiles, expecting Jones to fumble the response. Instead, the actor fixed Thomas with a steady gaze. "Justice Thomas, before pursuing acting, I studied geology extensively as part of my Harvard education. For the past 20 years, I've managed water conservation projects on my Texas ranch, implementing sustainable practices recognized by the Department of Agriculture. I've also funded 3 research projects at the University of Texas on aquifer contamination. My amicus brief draws on this experience and the expertise of 5 hydrogeologists who contributed to its creation." Jones spoke with quiet authority, but Chief Justice Roberts remained unsatisfied. "Mr. Jones, with all due respect, hobby ranching and financial patronage don't constitute scientific expertise. Your brief makes claims about contaminant permeability that contradict the EPA's own studies." The tension in the courtroom intensified. Justice Sonia Sotomayor appeared uncomfortable with the exchange's direction, while Justice Brett Kavanaugh studied Jones with unexpected interest. "Mr. Chief Justice," Jones responded, his voice remaining measured, "the EPA studies you're referencing, specifically the 2018 Phillips report, were based on a limited sample set from only 3 watersheds. If you'll direct your attention to page 57 of my brief, you'll find data from 17 additional watersheds that demonstrate a clear pattern of contamination migration not accounted for in the Phillips methodology." Roberts shuffled through the brief, frowning slightly. Jones continued, "Furthermore, Justice Roberts, the Phillips report's author, Dr. Elizabeth Phillips, has submitted a letter supporting my analysis, which is included in the appendix." The gallery murmured in surprise. Roberts hadn't anticipated this level of detailed knowledge. Justice Amy Coney Barrett, looking intrigued, posed her own question. "Mr. Jones, even accepting your scientific data, there remains the legal question of whether the Clean Water Act's definition of point source can be reasonably interpreted to include groundwater contamination that eventually reaches navigable waters. How do you address the textualist argument against such an interpretation?" It was a sophisticated legal question that would challenge even experienced environmental attorneys. Jones paused momentarily before responding. "Justice Barrett, I direct the court to Justice Scalia's opinion in Rapanos v. United States, where he emphasized that the Clean Water Act's primary objective is to restore and maintain the chemical, physical, and biological integrity of the nation's waters. While Scalia advocated a narrow interpretation of navigable waters, he never suggested that the Act's protective scope should be limited to direct discharges. Several justices appeared surprised at Jones's citation of Scalia, a conservative icon. Jones wasn't finished. Additionally, the statutory definition of point source includes the term conduit, which logically extends to natural hydrogeological features that function as conduits for pollutants. To interpret otherwise would create a loophole, undermining the Act's explicitly stated purpose. Roberts's expression had transformed from dismissive to unsettled. This was not the fumbling celebrity response he had anticipated. As Jones continued to field questions from increasingly engaged justices, the Chief Justice interrupted. "Mr. Jones, these are complex matters of statutory interpretation." "With respect, Mr. Chief Justice," Jones said firmly, "statutory interpretation is precisely what I'm addressing. The Clean Water Act's text, when read holistically rather than selectively, supports a functional rather than formalistic definition of point source pollution." The gallery tensed at Jones's respectful but direct pushback against the Chief Justice. Legal experts exchanged glances. They were witnessing something truly unprecedented. Roberts tried again. "Your interpretation would create unbounded liability for industries that have structured their operations around a narrower understanding of the law." Jones reached for his briefcase, withdrawing another document. "Mr. Chief Justice, I anticipated that concern. If you'll permit me, I've prepared an analysis of regulatory impacts based on the broader interpretation." As Jones began distributing copies to the justices, Roberts appeared increasingly discomfited. This was not proceeding as he had expected. When he'd called on the actor, seemingly hoping to expose his amateur legal understanding, instead, Jones was demonstrating remarkable command of both the scientific and legal dimensions of the case. The tension in the courtroom reached its peak when Justice Kagan posed a question that would lead to the most dramatic moment of the exchange. "Mr. Jones," she began, "Chief Justice Roberts raised an important point about regulatory expectations. How do you reconcile your interpretation with the court's traditional concern for regulatory stability and business reliance interests?" All eyes turned to Jones as he prepared to answer the question that had become central to many of the Roberts Court's administrative law decisions. "Justice Kagan," Jones began, his voice calm and deliberate, "I believe the court's concern for regulatory stability must be balanced against the statute's primary purpose. But I'd like to address the Chief Justice's point about industry expectations directly." He retrieved a final document from his briefcase, a thick-bound report with color-coded tabs extending from its edges. "What I hold here is something that hasn't been previously entered into the record, but which fundamentally changes our understanding of industry expectations. This is an internal petroleum industry assessment from 1989, conducted by the American Petroleum Institute's own Environmental Compliance Division." The courtroom fell completely silent. Even the seasoned Supreme Court reporters leaned forward. "With the court's permission," Jones continued, "I'd like to submit this document, which my foundation obtained through a Freedom of Information Act request 3 months ago. It has not been previously available to the public." Chief Justice Roberts appeared hesitant, but several justices reached for the copies being distributed by a court clerk. "This report explicitly acknowledges that groundwater contamination pathways would likely be covered under the Clean Water Act. On page 114, the industry's own legal team concludes, and I quote, "The most prudent legal interpretation suggests that contaminants reaching protected waters through groundwater transmission would fall within the Act's regulatory scope. Companies should prepare compliance strategies accordingly." Justice Kavanaugh's eyebrows rose visibly as he turned to the referenced page. Justice Gorsuch began making rapid notes. "In other words," Jones continued, "the industry has known for over 30 years that the broader interpretation was legally sound. They were not operating under regulatory confusion or uncertainty, as suggested. In fact, this report recommends specific containment technologies to prevent liability, technologies that were largely not implemented." Chief Justice Roberts, who had been skimming the document, looked up sharply. "Mr. Jones, how did you come to possess this report?" "As I mentioned, Mr. Chief Justice, through a legitimate FOIA request. The report was referenced in EPA correspondence that my foundation's environmental research team discovered While preparing our brief, the API had shared this assessment with government regulators in 1990, placing it within the public record, though it was effectively buried until our request. Roberts appeared momentarily at a loss for words. The industry's main argument that they had structured their operations around a narrow interpretation of the Clean Water Act had been severely undermined by their own internal documents. Justice Sotomayor seized on the revelation. Mr. Jones, this document suggests the industry anticipated potential liability for groundwater contamination pathways decades ago. How does this affect the reliance interests that Chief Justice Roberts referenced? Jones nodded respectfully. Justice Sotomayor, it transforms the question entirely. The court cannot protect reliance interests that never genuinely existed. The industry's public position contradicts their private legal assessment and operational planning. They weren't relying on a narrow interpretation. They were calculating the risks of non-compliance despite their own legal analysis. The point was devastating and delivered with the quiet authority that had characterized Jones's film performances for decades, but he wasn't finished. Furthermore, if I may address the Chief Justice's earlier concern about my scientific credentials, Jones turned to Roberts, who had regained his composure. I recognize that my primary career has been in film. However, I'd note that the court routinely accepts amicus briefs from organizations without questioning the qualifications of individual authors. My submission should be evaluated on its merits, just as you would assess a brief from any trade association or advocacy group. It was a subtle but powerful argument, effective pushback against the initial dismissive treatment. Several justices, including Kagan and Barrett, nodded slightly in apparent agreement. Roberts, recognizing that his strategic questioning of Jones had backfired spectacularly, attempted to regain control of the proceedings. Thank you, Mr. Jones. I believe you've clarified your position. We should return to the scheduled arguments. But Justice Kagan interjected. Mr. Chief Justice, I have one additional question for Mr. Jones, if you'll permit it. Roberts had little choice but to agree. Mr. Jones, Kagan continued, your brief proposes a specific test for determining when groundwater contamination falls under the Clean Water Act's jurisdiction. Could you elaborate on how courts might apply this test practically without creating the unlimited liability concerns that have been raised? It was exactly the question Jones had prepared for, focusing on the practical judicial application rather than just the scientific or historical evidence. He outlined a three-part test that balanced environmental protection with practical limitations. On liability, drawing on language from previous Roberts Court decisions on administrative law, Jones concluded, this approach respects the court's concern for administrable standards while fulfilling the statute's protective purpose. It provides clear guidelines for lower courts without requiring scientific expertise beyond what district judges regularly handle in environmental cases. Justice Barrett, who had been taking extensive notes, asked, your test incorporates a proximate cause element similar to what we've applied in other contexts. Was that deliberate? Yes, Jones confirmed. I structured the test to align with familiar judicial concepts. Proximate cause analysis is something courts are well equipped to handle, making implementation more feasible. The response reflected a sophisticated understanding of how the Supreme Court prefers to craft legal tests for lower courts to apply, a level of legal insight that few expected from the actor. As Jones finished his responses, the atmosphere in the courtroom had transformed. What began as what seemed to be Roberts' attempt to embarrass a celebrity interloper had become a masterclass in advocacy. Legal reporters were frantically taking notes, aware they were witnessing an extraordinary moment in Supreme Court history. Chief Justice Roberts, to his credit, recovered his typical professional demeanor. Thank you, Mr. Jones, for your contributions to these proceedings. Your perspective has been illuminating. The carefully chosen words acknowledged what everyone in the room now understood. Tommy Lee Jones had not only held his own in the nation's highest court, he had fundamentally altered the case's trajectory with both his legal reasoning and the stunning industry document he had uncovered. As Jones returned to his seat, Justice Alito was seen whispering to Justice Gorsuch, while Justice Kagan exchanged glances with Justice Barrett. Something remarkable had just occurred in the normally staid Supreme Court. A Hollywood actor had just delivered one of the most effective impromptu oral arguments many court observers had ever witnessed. Roberts called for a 15-minute recess, an unusual step in the middle of oral arguments. As the justices filed out, legal experts in the gallery began furiously debating the implications of what they had just witnessed. The American Petroleum Institute's attorneys huddled in urgent conversation, clearly blindsided by the revelation of their own internal report. The case that many had considered predictable now hung in the balance, transformed by a most unlikely advocate whose legal brilliance had stunned the highest court in the land. By the time the Supreme Court session adjourned that afternoon, the unexpected confrontation between Chief Justice Roberts and Tommy Lee Jones had already begun spreading through legal circles like wildfire. Court reporters rushed to file their stories, many rewriting their pre-drafted articles that had assumed the case would follow predictable ideological lines. CNN's Supreme Court correspondent was first on air. In an extraordinary development today, actor Tommy Lee Jones, yes, that Tommy Lee Jones, may have single-handedly changed the trajectory of one of the most significant environmental cases in decades. What began as an apparent attempt by Chief Justice Roberts to discredit a celebrity amicus brief ended with Jones revealing game-changing evidence and demonstrating a command of environmental law that stunned the court. Within hours, Jones vs. Roberts and Tommy Lee jurisprudence were trending nationwide. Legal blogs exploded with analysis while law professors scrambled to download Jones's amicus brief and the newly revealed petroleum industry document for classroom discussion. SCOTUS blog published a breaking analysis titled, "When the Men in Black Star Schooled the Supreme Court, Jones's Unexpected Impact on Clean Water Jurisprudence." The article noted, what appeared to be a potentially embarrassing moment for Jones transformed into one of the most effective impromptu oral arguments in recent court history. The Chief Justice's unusual decision to directly question an amicus brief author backfired in spectacular fashion, potentially altering the outcome of this landmark case. Legal Twitter erupted with commentary from prominent attorneys and scholars. Harvard Law's Lawrence Tribe posted, "In 50 years of following SCOTUS, I've never seen anything like today's exchange." Jones displayed remarkable legal acumen and revealed critical evidence that reframes the entire case, an extraordinary moment in Supreme Court history. Fox News took a different angle. Hollywood elite lectures Supreme Court. Actor Tommy Lee Jones pushes liberal environmental agenda. Yet even their legal analysts acknowledged that Jones's argument had been surprisingly substantive. Whatever your position on the environmental issue, it's clear that Jones came extremely well prepared and raised valid legal points that the court will have to address. Clips of Jones's film roles as determined lawman began circulating online, now juxtaposed with court sketches of his Supreme Court appearance. Memes flooded social media, comparing his character from The Fugitive saying, "I don't care," with court artist renderings of his composed responses to Roberts' questioning. The petroleum industry responded with a hastily arranged press conference. The 1989 document referenced in today's proceedings was a preliminary assessment that was later superseded by more comprehensive analyses, claimed the American Petroleum Institute spokesperson. Though reporters noted that no such superseding documents were identified, environmental groups caught by surprise by Jones's intervention quickly capitalized on the momentum. The Sierra Club issued a statement. "Mr. Jones's contribution today demonstrates that the scientific and legal case for protecting our nation's waters from all forms of pollution is overwhelming. We are grateful for his meticulously researched brief and his powerful advocacy." The following morning, Jones appeared on NBC's Today Show. When asked about the confrontation with Roberts, he remained characteristically understated. "I have tremendous respect for the Chief Justice and the entire court. My goal wasn't to challenge anyone personally, but to ensure that all relevant information was before the court as they consider this crucial environmental question. Pressed about his preparation, Jones revealed, "I spent nearly a year working with scientists and legal experts to prepare that brief. The document we uncovered through FOIA was significant, but it only confirmed what the scientific evidence already showed, that groundwater contamination pathways have been well understood for decades." Meanwhile, legal education felt immediate impacts. Georgetown Law announced a special symposium titled Celebrity Advocacy and the Supreme Court: Lessons from the Jones Brief. Harvard Law School requested permission to include excerpts from Jones's brief in its environmental law curriculum. Northwestern University Law Review expedited a special issue on amicus brief influence, with Jones's intervention as its central case study. Behind the scenes, sources close to the court reported that the justice's private conference on the case had been unusually animated. According to one clerk who spoke anonymously to the Washington Post, the industry document changed everything. Justices who might have sided with a narrow interpretation are now grappling with evidence that even the industry itself didn't genuinely believe in that interpretation. It shifted the entire conversation. Legal analysts began predicting outcomes that would have seemed impossible just days earlier. Before Jones's intervention, most experts expected a 6-3 ruling favoring industry, noted SCOTUS blog. Now a majority supporting broader Clean Water Act protections seems entirely possible. Congressional attention followed quickly. The Senate Environment Committee announced hearings on groundwater protection, with Chairman Tom Carper citing disturbing new evidence regarding industry awareness of contamination pathways. The EPA initiated a review of its enforcement policies regarding groundwater contamination. The most significant public response came 1 week later when Chief Justice Roberts addressed the annual Fourth Circuit Judicial Conference. Without mentioning Jones or the specific case directly, Roberts spoke about the court's openness to diverse perspectives. The Supreme Court's consideration of complex cases benefits from input representing various expertise and viewpoints, Roberts said. While legal training provides an essential foundation, we recognize that valuable insights can come from many sources. The court's duty is to evaluate all contributions based on their substantive merit, not their origin. Legal analysts immediately recognized this as Roberts's oblique response to criticism of his initial approach to Jones. The New York Times judicial correspondent wrote, Roberts's remarks represent a remarkable acknowledgement that his handling of the Jones brief may have reflected an unwarranted presumption about who can contribute meaningfully to legal discourse. It's a subtle but significant act of judicial humility from the Chief Justice. As the weeks passed, the story evolved from a viral moment to a serious case study in advocacy and judicial receptiveness. Law review articles analyzed the substantive legal arguments Jones had presented, generally concluding that his proposed test for groundwater regulation was legally sound and administratively workable. Environmental law professors incorporated the case into their teachings. Jones's intervention has become a textbook example of effective advocacy, noted Professor Richard Lazarus of Harvard Law School. He combined scientific expertise, legal reasoning, and strategic evidence presentation in a way that many seasoned attorneys could learn from. 4 months later, when the court's decision was finally announced, legal observers were stunned but not entirely surprised. In a 6-3 opinion authored by Justice Kavanaugh, with Roberts joining the majority, the court held that the Clean Water Act covered groundwater contamination that represented the functional equivalent of a direct discharge into navigable waters. Kavanaugh's majority opinion directly cited the industry document Jones had introduced. The regulated community's own contemporary understanding of the Act's requirements, as evidenced by internal compliance guidance, confirms that our interpretation today does not impose unexpected obligations. The opinion went on to adopt a modified version of the test Jones had proposed for determining when groundwater contamination fell under the Act's jurisdiction, providing clear guidelines for lower courts. Perhaps most remarkably, Chief Justice Roberts wrote a concurring opinion that specifically addressed Jones's contribution. The court benefited from unusually thorough amicus participation in this case, including submissions that directed our attention to relevant evidence and thoughtful, analytical frameworks for applying the statute consistent with its purpose, while respecting practical limitations. It was as close as the Chief Justice would come to publicly acknowledging that his initial skepticism of Jones had been misplaced. Justice Alito's dissent, joined by Thomas and Gorsuch, argued that the majority had expanded the Clean Water Act beyond congressional intent. Yet even the dissent acknowledged that the industry document complicates claims that regulated entities lacked notice of potential liability. The practical impact was immediate and far-reaching. Within a year, the EPA had initiated over 60 enforcement actions against facilities with groundwater contamination issues. States revised their own water protection programs to align with the court's interpretation. Industry groups, while concerned about compliance costs, began adapting to the new legal landscape. An economic analysis by the University of Chicago estimated the ruling would prevent drinking water contamination affecting over 12 million Americans, while industry compliance costs would reach approximately $4.7 billion over 10 years. Substantial, but far less than the apocalyptic predictions advanced during litigation. Tommy Lee Jones never publicly took credit for influencing the outcome. When asked about the decision during an interview promoting a new film, he simply said, "The justices made their decision based on the law and the evidence. I just happened to have some relevant information to contribute to that process." Nevertheless, his impact on environmental advocacy was profound. Other prominent individuals with specialized knowledge beyond their public personas began filing more substantive amicus briefs in their areas of expertise. The quality of public participation in Supreme Court cases measurably improved, with more rigorous scientific and economic analyses supporting both liberal and conservative positions. Law schools added sections on effective amicus advocacy to their appellate practice courses. The American Bar Association published guidelines for non-attorney participation in Supreme Court cases, emphasizing substantive contribution over celebrity. The most personal aftermath remained private until years later, when a retired Supreme Court clerk published a memoir. In a chapter titled "The Day Tommy Lee Jones Transformed a Case," the clerk revealed that Chief Justice Roberts had privately told his colleagues afterward, "I made an error in judgment today. I allowed my preconceptions about Hollywood to cloud my assessment of a substantive legal argument. It won't happen again." The story of Roberts and Jones became more than a viral moment or legal anecdote. It evolved into a parable about expertise, humility, and the unexpected ways justice can advance when substance is valued over source. As for the wider public, the confrontation remained a fascinating example of what happens when assumptions about expertise collide with demonstrated knowledge, and how sometimes the most effective advocates come from outside traditional legal circles. The real lesson wasn't about celebrity or judicial authority, but about preparation, respect for evidence, and the democratization of legal advocacy in America's highest court. This extraordinary confrontation between Chief Justice Roberts and Tommy Lee Jones reminds us that expertise can come from unexpected places, and that careful preparation and genuine knowledge can overcome even the most entrenched skepticism. It shows us that justice is best served when arguments are evaluated on their merits rather than their source, and that even the highest legal authorities can learn from voices outside the traditional legal establishment. If you found this court drama as fascinating as we did, don't forget to like this video and subscribe to our channel. We'll be bringing you more incredible legal confrontations and political showdowns that shaped American law. Leave a comment below telling us which Supreme Court case or unlikely advocate you'd like to see featured next.